Hello and welcome back to my channel. My name is Joanne. I am the lawyer or the learn or whatever you want to call me. You can call me anything you like as long as it's not late for dinner. I hope you've had a Christmas. New Year is quickly approaching. Please accept my apologies for not being live. I have been living life. I've had Christmas with my family. I actually hosted. Had a great time hosting Christmas, and then we've had the Christmas and the New Year where you don't know what day it is, you don't know what you're doing, you're still eating leftovers, and anyway, so we're quickly approaching the New Year. Anyway, I just happened to be looking around. I discovered that there were a whole pile of documents that were uploaded. I don't know when these were filed. I need to have a look. There was a whole pile of documents uploaded into the system in Minnesota on the 23rd. Okay, so we had some on the 9th to the 12th. We've had a memorandum of 20 pages, an affidavit of 43 pages, another document of 14 pages, and a responsive motion. So I can tell, you can take a guess as to who's written what. Now, some of these, I must say, there is another. The other document is still just are still just exhibits to exhibit to the affidavit. But anyway, this is what we've got. So some of these are long. Some of these are just very long. So we want to see. So what's happened is, so we've got here a memorandum, we've got an affidavit, we've got another document and a responsive motion. Now the responsive motion, I think, let me have a look. Written by. That one's Jennifer Moore. Plaintiff's response to memorandum of law to opposition. So this one is, which is 7 pages, by the way. That's been written by 7M. So we've got, so they're this is their opposition to the motion from the, and then we've also got a 5th declaration of Jennifer Moore. Oh, gee, and there's just been a big glaring typo stick out at me. And I look, sometimes when they're done, it's very easy to make typos in legal documents, but it's Instagram. So let's start with the memorandum, the page one. So this is a memorandum, defendant's memorandum of law opposing plaintiff's motion for summary judgment. So don't forget that there was also a motion of summary judgment filed by the plaintiffs. Now, as for timelines and everything like that, I don't know as far as timelines are concerned or anything like that. I just hope, and I hope you can all hear me. So let me know if you can hear me, because otherwise I'm talking to myself, and I do that a lot. So hopefully you can hear me. So this filed on the 23rd of the 12th, 2024 at 2:24 p.m. Hi, short order. So unfortunately, the watermark is blocking that off. So, but just under here, it says filed 23rd of the 12th, 2024. This is 20 pages long. So it says defendants Catherine Mansky Paulson, aka Katie Joy, submit this memorandum of law opposing plaintiff's motion for summary judgment. It says on the 24th of February 2022, Melanie, Kelly, and Dean Milking went live on Instagram to tell the world how Melanie's sister, Miranda, had disappeared from their lives. In a video that lasted more than an hour, the Wilkins described how Miranda and her then boyfriend, James Derrick, had become involved in the Shekinah Church and the talent management company 7M Films, owned by the church's pastor, Robert Quinn. They stated that they had not seen Miranda for over a year, and that when her friends and family attempted to reach out to Miranda, they found themselves blocked on social media and text. They spoke about how their daughter seemed to be a completely different person from the one that they knew. They discussed how they observed financial irregularities in Miranda's accounts. They discussed their efforts to contact their daughter. The video depicts a family very much in pain over Miranda's loss. Hello without a lawyer. Yes, nearly New Year. Do you know what day it is? Because I still don't. I just know I have certain things. I just have appointments, reminders set up, and I just go do whatever I'm supposed to do. Anyway, so that's really makes it sound like a very diabolical situation, actually. A family very much in pain over Miranda's loss. Oh, dear. At the time of the video, Melanie Wilking had hundreds of thousands of followers between TikTok and Instagram. So it is perhaps not surprising that the story was picked up by numerous media outlets, including Without a Crystal Ball, Catherine Paulson's social media channel. Paulson stands by her reporting. While WOACB is not a traditional publication, it does have hundreds of thousands of viewers and a significant reach. Paulson's reporting about the plaintiffs and the Shekinah Church was sourced by interviews with former members of the Shekinah Church, former 7M dancers, and colleagues. Friends and family members of 7M dancers, court records, and other publicly available documents. Paulson's motive was to report the story that she had no connection to apart from her interest on a matter of public interest. That whole statement contradicts what she said on the thing where she said she wanted to help them to get their daughter back. But the Wilkins had stated a year of not seeing Miranda. Miranda didn't agree with that. Wasn't Miranda seeing her family? Yes, I thought they were seeing each other. It all came about because there was an issue over one of the grandparents' funerals. Wasn't that the point that everything went weird? And you're correct, Shekinah is not suing her. As I said, you need a highlighter pen as you go over oh, gee whiz. A highlighter? No, I tell you what, I need a lift drip to try and make sense of this, I think. I don't think coffee's going to cut it. I don't think it's going to cut it. Anyway. Yeah, I'm not leaving the house much either, to be fair. I just can't be bothered, to be honest. The other thing is I was supposed to have a rent inspection before Christmas. The agent didn't turn up, and they haven't responded to any of my calls to tell me what's going on. But I tell you what, I got my house clean before Christmas though. So, see, in my opinion, right, all of her stories or retelling of this involvement with the Wilkins should all be cohesive and match, but none of it matches, and that is the issue that I've got. Most of all, is that her stories aren't matching, because she's told a different story now. All right. Plaintiffs would have this believe that all of their financial woes are due to WOACB coverage. They would like the court to ignore all the other publications that have reported on Miss Wilkin and her involvement in the Shekinah Church. It's Miss Derrick. They would like the court to ignore the fact they have sued bloggers in California for the exact same coverage, for the exact same injuries. As defendants stated in their introductory section to their memorandum in support of summary judgment, the defendants have brought this lawsuit because they don't like news coverage that's getting from all over the world. But they can't afford to sue every outlet. So they've picked up. Hang on a minute, is this supposed to be a legal document? Or is this a script for a drama? This is... Is this high school? So they've picked publishers of information that do not have bottomless economic resources to send a message that reporting on them is too expensive. They don't care if they win or lose. They simply want to make sure the lawsuit is too expensive to risk. The summary judgment motion exemplifies this tactic. Affirmative motions for summary judgment are only brought when the facts are so heavily weighed in favour of a party that no reasonable mind could find a disputed issue of material fact. In this case, plaintiff's motion barely discusses the evidence supporting the elements they are required to prove in order to establish their right to recover. In many cases, plaintiffs make no citation to documents or testimony that... Actually, I thought they did. The statements are false. I don't know. I have no idea. This is pretty. You put your point, your proof of law, and then an explanation. Plaintiffs have presented no evidence that Paulson knew the information she was presenting was false, and they ignore the record of all the steps she took to report on this story. Plaintiffs present no evidence of existing financial relationships with businesses they claimed defendants wrongfully interfered with. They certainly do not present any evidence that would indicate what defendants said to these companies. They cite the wrong standard for absolute malice, and they tell the court that defendants should be held liable for negligence per se, based on a violation of statute that has been declared unconstitutional. It is clear that the plaintiff's motion was brought for no other purpose than to require defendants to have to expend money and resources. For this reason, and because plaintiffs simply have not presented a case that would warrant summary judgment, defendants ask this court to deny plaintiff's motion of summary judgment. And so then we've got statements of issues. So plaintiffs are not entitled to summary judgment on their defamation claim because A, defendant's statements were privileged and or non-defamatory. Plaintiffs are not entitled to summary judgment on their case for defamation per se if the statement was subject to qualified privilege. Plaintiffs are not entitled to summary judgment on their claim for commercial defamation if the statement were subject to a qualified privilege. The other thing is, we also, and it also depends on whether she's a bona fide journalist or not. Let's get that fact right too. The way the court will treat the statements would depend on whether she's a journalist or not. So then they're not entitled to summary judgment on the tortious interference because it's fully protected under the First Amendment and justified under refusal to deal doctrine. Plaintiffs, because underlying statute was declared unconstitutional, and they're saying that they failed to present evidence. So then they're saying, here's all the records, documents comprising on the record. everything that's going to prove their case. And they're using news articles. Now, remember, if the timings of the news articles were after she started covering it, it could be argued that they covered it because she was covering it. So these are just all. So then she's got the 5th declaration of Jennifer Moore. Okay, so facts. Fully incorporate the statement of undisputed facts. As defendants only address those facts were newly raised by plaintiffs in their motion of summary judgment. The plaintiff's amended complaint lists approximately 86 posts that they contend were either defamatory or otherwise objectionable. This affirmative motion for summary judgment. Plaintiffs narrow that list down to 21 posts, several which were not referenced in the complaint at all. Ms. Stavek's affidavit attaches 5 exhibits that were posted after the amended complaint was served. Exhibits 21 to 25. Exhibits 1, 2, 7, 9, 14, 15, and 20 reflect content that does not appear to be referenced in the complaint, and plaintiffs have produced no evidence that they were ever published. Exhibit 17 was lightly described in the complaint, but the link provided did not go to the published post. Exhibits 10 and 11 were not referenced in the amended complaint. Exhibits 3 to 6, 8, 12, 13, and 16 to 19 appear to be content that was listed in the amended complaint. Defendants have discussed these posts at length in the memorandum supporting motions and will reference the court. So they're saying linking complaint, link located by defendants. Now, when we get to the plaintiffs will talk about a OneDrive. So their argument is that because the link doesn't work anymore, it therefore can't be used. So these are the complaints here. So she's found plaintiffs' memorandum in support of their motion for states that 10 and 11 were editable as follows. So 10 and 11. On March 6, 2022, defendant posted Mr. Derek's TikTok live video stating she is safe, she's not in a cult, she's married and doing great despite the lies being spread about her online. Nonetheless, on March 7, 2022, defendant posted that 7M is a religious cult and tells her followers not to interact with 7M. On March 8, 2022, defendant posted Mr. Chin as a cult leader and his clients are victims. He asked clients to live on the property and he claims that God instructed him to teach women about sex. So I don't know why she's posted that in there. Because she's posted that in as that was one of the objections. So here's standard review. Summary judgment is appropriate when there is no genuine issue of material fact, and the party is entitled to a judgment as a matter of law. Any party with a claim against them may move for a summary judgment in its favour in full or part. A motion for summary judgment shall be granted with the pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavits, if any, show that there's no genuine issue of material fact that either party is entitled to as a matter of law. Hello, Foxy. A genuine issue of material fact must be established by substantial evidence. In Murphy, the court explained that while what constitutes substantial evidence is not defined, it has been applied to require sufficient evidence to avoid a directed verdict at trial. So here's my question to you. If it's an Instagram post, is that deemed to be direct? Would you say that that's direct evidence to substantiate a claim? Because I don't know what they're trying to. Are they going to try and say now that she never posted them? Once the moving party has established a prima facie case that establishes it to summary judgment, the burden shifts to non-moving party to prevent specific facts to raise a genuine issue for trial. Evidence presented upon a summary judgment motion must be taken in light most favourable of the non-moving party. To be honest with you, I can't see either side getting a summary judgment, to be fair. While summary judgment is intended to secure a just, speedy, and inexpensive disposition. It is not designed as a substitute for a trial where there are issues to be determined. Because in my opinion, there are issues. There are too many. In my opinion, they still have to have it determined whether she's a journalist or not. Because if she is a journalist, qualified privilege may actually be a strong defense. But if she's not a journalist, qualified privilege may not be a strong defense. They've got to decide whether they can't agree whether she needs a public figure or not. Again, it all changes how the law is interpreted based on those facts. So I cannot see how the judge could give a summary judgment to either party when those important facts have not actually been determined. Again, this is just my opinion. Because remember, summary judgment means that there has to be facts that can't be disputed. And if Katie is using qualified privilege or the First Amendment for journalism or something, or trying to say that she's protected by journalism, then the question of whether she's a journalist has to actually be determined. As I said, my opinion. Summary judgment is not appropriate when reasonable minds could differ and draw different conclusions from the evidence presented. That's what I was just saying. The way that you interpret the evidence will solely depend on a number of factors, right? And so the way the evidence is interpreted changes based on the way that those questions are answered. So this is why I can't see that summary judgment could be granted by either party. Nevertheless, there is no genuine issue of material fact for trial when the non-moving party presents evidence which merely creates a metaphysical doubt to a factual issue and which is not sufficiently probative with respect to the essential element of the non-moving party case to permit reasonable persons to draw different conclusions. Okay? So they're saying, so again, we're going to get into this privileged. And again, whether the information is privileged may come down to whether or not she's a journalist. To establish a claim of defamation, plaintiff must prove three elements. The defamatory statement is communicated to someone other than the plaintiff. A, it was, fact. The statement is false. That's, in my opinion, some of those statements there's a couple of false statements in that. The statement tends to harm the plaintiff's reputation and to lower the plaintiff in the estimation of the community. That's correct. However, plaintiffs cannot recover if defendants' statements were privileged under New York Times versus Sullivan. Defendants' memorandum in support of its motion for summary judgment explains that publishers of information relevant to public discourse are entitled to qualified privilege, which can only be defeated by showing of absolute malice. Now, issue publications, and then if she's a publication, so this is where, in my opinion, the grey area applies, and the judge actually will need to make a determination before the judge can actually. The judge will have to make a determination as to how they're going to treat qualified. How they're going to treat whether it's a publication, and then we've got the journalism side, and don't forget that can all be also challenged as well. Plaintiffs acknowledged that the statements made about them were matters relevant to public discourse, but contend the defendant's statements were not privileged because they were made with actual malice. However, plaintiffs, well, see, that's a disputable fact, right? That's a fact up for dispute, which means it doesn't meet the criteria for summary judgment, in my opinion. However, plaintiffs have confused common law malice with actual malice. Certainly, if the standard for the plaintiff's speech were common law malice, plaintiff would be entitled to investigate intrinsic evidence of malice to defeat the qualified privilege. However, the defendants are speaking on matters of public concern. Plaintiffs must establish actual malice. And again, another disputed fact, was it a matter of public interest? So remember, summary judgment can only be determined if there are undisputed facts. And I think there are too many disputable facts. And as I said, I don't know how. Because remember, Shekinah Church only had a handful of people in it. And there was only a handful of people affected. So is it really damaging? Was it a public issue? And then we've got, was it a public issue or was it a family spat? Okay. All right. The Supreme Court provided a technical definition of actual malice as knowing or reckless disregard for the truth, or a falsity of statement has nothing to do with motive or ill will in the publishing of otherwise defamatory statements. In my opinion, I think some of those statements are a reckless disregard for the truth. Because if she just stated certain points, nobody would be interested. But when she starts talking about waterboarding and human trafficking and all this other stuff, people are paying attention. And that's where we get to reckless disregard of truth. Again, my opinion, my interpretation. So to defeat the qualified privilege, plaintiffs must state that the defendant's statements were made knowing that they were false or with a reckless disregard for their truth or falsity. This analysis makes sense when there is little evidence that the publisher knew that the subjects of her reporting prior to publication. But she'd made a promise to the Wilkins that she'd do whatever she could to get their daughter back. So that comes down to, there's your malice, and that means that you could be reckless regarding the truth for the purpose of getting the daughter back. Because have you noted, I mean, the biggest red flag, in my opinion, in that documentary was that it did not address the statement Miranda and James made immediately after the video from the Wilkins. She talked about where Melanie explained the situation about the grandparents' funeral, and James said he felt unsafe, and she was talking about feeling unsafe. That was all left out. See, and that's the thing. It's a promise. Now, so then we get to, is making a promise to somebody, can that then lead to malice? Is that the same as malice? And this is all that has to be reported. Okay. So, but I think it's more of a reckless disregard of truth, more so than falsity. And then it says, moreover, it affords Miss Paulson the same rights enjoyed by Rolling Stone or Business Insider. Plaintiffs have clearly failed to establish that the defendant's statements were made with actual knowledge that they were false or with a reckless disregard of truth or falsity. A claim for defamation must be placed with specificity, including who made the defamatory statements, to whom they were made, and where. And then there's some cases. It must be pled with a certain degree of specificity and must adequately identify the false and defaming statements in which the defendants made the statement. One purpose of the specificity requirement for the claim. Yes, correct. They went from her reporting. We know that. To provide sufficient to put defendants on notice of what defamatory remark he or she allegedly made. Here, the plaintiffs have played a shell game. Their complaint identifies specific statements they claim to be defamatory, complete with the hyping specific content they claim to be defamatory. Now, plaintiffs have identified completely different posts long after discovery is closed, and defendants have lost any opportunity to oppose witnesses as to this content, much less examine the claimed defamation as the totality of the defendant's reporting and the greater context of news coverage related to the Derrick's involvement with the Shekinah Church and 7M Films. And I know that she'll throw the sources under the bus short order too. I mean, Exhibit 3, plaintiffs contend that Exhibit 3 is defamatory insofar the defendants posted that plaintiffs are involved in a cult and their behaviours are compared to Jim Jones and R. Kelly. Statements that a religion or group constitutes a cult have not been determined to be defamatory. In a district court decision, it was the very definition of a cult may very well vary from individual to individual based entirely on the individual's perception. Moreover, if one could settle on a single or universal definition of the word cult. Applying such a definition to a number of different entities of situations might very well engender different responses to the question, is it a cult? This is because each item of a universal definition of the concept of cult would be dependent upon an individual's particular values and belief system. Quite simply, matters of faith or religious beliefs are personal. As defendant argues, as the Court of Texas of Appeals have previously housed in the Harvest House publics, this court cannot determine the truth or falsity for ecclesiastical matters which fall outside the proper bounds of what a court may decide. So they're sort of saying because there's been no definition of what is a cult, then therefore it can't be defamatory. However, comparing Shin to Jim Jones and R. Kelly could actually be defamatory. Plaintiffs and their behaviours were compared to Jim Jones, and to say that behaviours like Jim Jones or R. Kelly could be deemed defamatory. How can she her reporting through other outlets evidence of proof when it's her hearsay reporting? Yes, and we know that she's likely to have provided all the information to the other publications anyway, and that's all been left out. So in the bad register, thus statements pertain to doctrinal matters such as whether a church is a cult, how it collects tithes, whether the organisation subscribed to particular doctrines, what is said in worship, and the relationship between pastor and parishes are subject to this ecclesiastical abstention doctrine. At least one court has determined that to hold otherwise would be violative of the free exercise clause in the US Constitution. So explain that statements that an organization is a cult and an individual is a cult recruiter are pronunciations of religious belief and opinion, because these are not factual statements capable of being proven true or false. They are not actionable as a basis in a defamation claim. Thus, a course of action cannot lie where because these are not factual statements capable of being proven true or false, they are not actionable as a basis of defamation. Plaintiffs may argue, it says, in fact, the best the defendants could do in attempting to discuss the definition of a cult was to state that Paulson had a different definition to what they had. Miss Derrick stated that a cult was culture. Mr. Derrick couldn't define it at all, and Mr. Shin acknowledged that the definition of a cult is complex. Plaintiffs may argue that the statements would be protected as to the Shekinah Church, not be protected as to 7M Films Inc. However, it was Paulson's opinion that the unity of interest between leadership and membership of Shekinah Church and 7M Films rendered the organization interchangeable for the purposes of discussing doctrine. It is notable that Shekinah Church is not a plaintiff hearing. As a result, defendants had no opportunity to determine whether statements made about Shekinah were true. Well, stop talking about Shekinah! However, again, so Paulson's opinion was that the unity of interest between the leadership and membership of Shekinah Church and 7M rendered the organizations interchangeable. What qualifications has she got to render them together and interchangeable for the purposes of discussing doctrine? Where's her proof that they're interchangeable? Just because you have the people on the board of directors doesn't mean that they're not separate entities. Anyway, Exhibit 3 is a video that is almost 25 minutes long. No, she hasn't. Plaintiff's description of the video is misleading. In the video, Paulson discusses the general nature of cults and warns that cults become more insular, the conduct of their leaders becomes more extreme. Paulson's use of examples of Jim Jones and R. Kelly were designed to explain the dangers of this increasing insularity. She indicated that the Shekinah Church's desire to acquire a sanctuary was an indication that the organization was tending towards this insularity. The church's desire to acquire a sanctuary, isn't that just like a church hall? How does that make you insular? Anyway, clearly this video is nuanced discussion that cannot fairly be reduced to the statement that Shekinah Church is like Jim Jones or R. Kelly, and therefore is defamatory. Plaintiffs also contend this is defamatory because Paulson stated that Mr. Shin through 7M does not let Miranda Derrick drive or go out public without monitoring. In fact, the video cites reports by others that Miss Derrick was not allowed to be alone and that she always had eyes on her on a shoot. Exactly, dribble and hearsay. It does state that Miss Derrick appeared to be driven everywhere. Plaintiff's memorandum does not state how this statement would constitute defamation or how this report was made with knowledge that it was false or with reckless disregard of its truth or falsity. As far as I know, if you're anybody of anywhere living in LA, you wouldn't be driving, you would be driven. Is that correct? I would drive. If somebody wanted to drive for me, I'd be more than happy to have them drive for me. Finally, the plaintiffs contend this video is defamatory because it accuses Shin of human trafficking. Plaintiffs have cited no evidence that this is not true. That said, the post is Paulson's opinion based upon her commentative reporting that the Wilkins concerned that Miss Derrick wasn't being paid and allegations by Lydia Chung that she was not paid for her work for Shin's businesses. Yeah, but that was proven to be, yes, but she got repaid. But that doesn't mean it's human trafficking. So because there are allegations that people weren't getting paid for their work, therefore it's human trafficking. That's not the definition of human trafficking. All right, plaintiffs contend Exhibit 4 was defamatory because Paulson said that the Derricks were not legally married, and members of Shekinah Church told her that the Derricks were instructed to be married by Mr. Shin. However, the record reflects the work that Paulson did to ascertain whether they were married. Yeah, and don't forget, he was taught he had to repay her. That went to court, and that got sorted out. So, yeah, that's right. That's a labour law issue, not a trafficking issue. However, the record reflects the work that Paulson did to ascertain whether they were married and why she was motivated to conduct this search. In short, the Wilkins family posted a video on February 24, 2022, in which they stated they did not know if the Derricks were legally married. Yeah, but that wasn't Katie's, Katie, that's not Katie's job to find out whether they were legally married. If the Wilkins wanted to, they could have just asked their daughter. Anyway, Paulson also received information from Lydia Chung during her involvement with Shekinah Church. Members were directed to partner and unpartner. Paulson received information from 2 other 7M dancers legally married to other individuals and thus could not be married to those identified as their spouses on their social media posts during their time they were 7M clients. Paulson also indicated she attempted to locate marriage records for the Derricks, and in California, some of the records are public. The first time Paulson received a copy of the Derricks' marriage certificate was in Discovery. So Paulson seemed to believe that the Derricks' claims on social media should have been sufficient to overcome any assertion of qualified privilege. That is not so. Defeat an absolute privilege, plaintiff must prove Paulson actually knew that what she was publishing was untrue or that her statements were made with reckless disregard of the truth or falsity. Oh, no, Ruth. Well, that's interesting. Look, I've heard about that. I heard that he made some merch on his cricket, and she spelled it Cricket. That's a game. Paulson was not obliged to take plaintiffs at their word under the theory of defamation. Moreover, although the Derricks' marriage certificate might be sufficient to prove the statement was false, plaintiffs do not even pretend to establish that any other elements of defamation have been satisfied as a matter of law. Plaintiffs have submitted no evidence that these statements caused them reputation harm or that they suffered damages as a result of Paulson's statements. You only got to look at their TikTok accounts to see what was going on there. They have been hammered on TikTok and they lost people. They lost supporters during this time. Oh, yeah, that's right. He's warning machine. Plaintiffs contend that Paulson's statements that 7M does not promote its female dancers is defamatory. Plaintiffs produce no evidence that this statement is false. Such evidence might include the steps 7M Films takes to promote its female dancers as compared to efforts it undertakes on behalf of males. Yes, she's using the absence of evidence. It is in fact a matter of opinion, and this cannot be basis of a lawsuit for defamation. Plaintiffs contend Exhibit 6 is defamatory in it that states that posted that 7M dancers' lives are so tightly controlled and blocking their family from contacting them. Defendants posted that 7M controls their bank accounts. Defendants said on March 3, 2022 that LA Clippers cancelled their contract with 7M. Paulson's reporting was based on a number of reports, but primarily concerns raised by the Wilkins family in their video. So we come back to this Wilkins family video, right? Plaintiffs do not allege that the LA Clippers did not cancel their contract with 7M. It all comes back to this Wilkins family video, and it would all come back to that conversation that she had with them. But primary concerns raised by the Wilkins family in their video. And yet that is what she posted based on, Exhibit 8. Plaintiffs cite the video to establish absolute malice. Defendants stated on the 5th of March 2022 that her views on her social media content regarding the plaintiffs are doing very well. Defendants are in the business of capturing a social media audience, just like every news outlet. Business performance is not evidence of absolute malice. You think? Well, I also think GRB actually has a fairly that could have a very strong claim. I heard that I saw something about her and Camille had broken up. They're no longer friends. She's going after Camille too. They've had a bit of a buster too. So anyway, plaintiffs allege that Exhibit 12 states 7M is a cult leader who SAs women and engages in human trafficking. Exhibit 12 does not contain the words SA, sexually abuses, human, or trafficking. Plaintiffs allege that this post states that MAC Cosmetics are not partnered with 7M. Plaintiffs do not allege that this statement was defamatory. They don't make any allegations that plaintiffs allege this post encouraged followers to harass Forever 21 to get their brand cancelled. There's no allegations this was defamatory. Plaintiffs allege that on the 30th of March 2022, defendant posted Mr. Shin was forcing Miss Derrick to hang on. Read this with me. Let's read this together. Plaintiffs allege that on March 30, 2022, that Mr. Shin was forcing Miss Derrick too fast because it is one of his teachings when she got a brand deal to Dough Fasting app. Deal with Dough Fasting app. Plaintiffs have submitted no information that would allow this court to find its post-defamatory. Oh, really? Oh, I've been blocked. She blocked me. She blocked me from TikTok now. So they're saying that they're not for defamation per se. Defamation per se differs from defamation only in that plaintiffs would not have to prove reputational harm because harm is presumed. However, plaintiffs cannot recover on a theory of negligence per se if the statements were qualifiably privileged. In Ritchie, plaintiffs sued when Maury Povich show published a picture of them with a high school graduate who'd been aided by her parents. Plaintiffs were not her parents and sued, claiming that showing this picture would lead an audience to conclude that they were, in fact, the individuals who aided the graduate. The Minnesota Supreme Court held that the publication was in connection with a matter of public concern by a national media outlet, and thus, in the absence of evidence of absolute malice, could not form the basis of recovery on a theory of negligence per se. In this case, the publication was related to a matter of public concern related to public figures, published by an internet entertainment outlet with a national audience, and plaintiffs have produced no evidence that would tend to show actual malice. As a result, plaintiffs are not entitled to award a summary judgment of negligence per se. In my opinion, this is disputable. Was it a matter of public concern? Were they public figures? And an internet entertainment outlet? I thought she called herself an archival consultant or a blogger, right? If these three things were true, right, it is probably correct that they would not be able, that qualified privilege would stand. If only two of these things would, if it was a matter of public concern and they were public figures, but she wasn't deemed an entertainment outlet, it would be different. So, as I said, there has to be undisputable facts established, and in my opinion, it's disputable. Are they public figures? Is she an internet entertainment outlet? And was it a matter of public concern? So again, we're back to qualified privilege. So, however, just as in the case of defamation per se, no recovery lies if it were non-qualified privilege. Here, plaintiffs are failed to establish evidence of absolute malice, and therefore are not entitled to summary judgment. And then justified under a refusal to deal doctrine is that, so the element of tortious interference with prospective advantages are intentionally and improperly interfering with another's prospective contractual relation by either inducing or otherwise causing a third person not to enter into or continue prospective relation, or B, preventing the other from acquiring or continuing prospective relation. Does she still own or in partnership with her own production company? She said that. I don't know. Yeah. Oh, that's right. So then it says interference with prospective advantage means intentionally and improperly interfering with another's prospective contractual relationship by inducing or causing third person not to enter. So this is what the judge has to work out, whether these are the elements, and in fact you have to have a tick every element. So was there an action that caused the third person not to enter or cease a relationship with another, or prevent another person from getting or continuing the relationship? Tortious interference with prospective advantage protects an interest in a reasonable expectation of economic merit. For the same reason that plaintiffs are not entitled to summary judgment, there's a plaintiff's tortious interference contract claim. Plaintiffs are also not entitled to summary judgment on the tortious interference with prospective advantage. Right. So plaintiffs acknowledge that with the exception of the LA Clippers, defendants did not directly contact any customers. With respect to LA Clippers, plaintiffs cite to the deposition of James Derrick, who they say testified he received information from his social media channels that Paulson had in fact contacted the LA Clippers. Plaintiffs did not produce evidence of this post. It is possible that Mr. Derrick was confusing a post that Paulson made reflecting someone else's post at best. Mr. Derrick's testimony indicates that there is a fact issue as to whether Ms. Paulson contacted the LA Clippers. Plaintiffs also alleged that Ms. Paulson posted that Sutter Homes were no longer partnering with the plaintiffs. However, Exhibit 12 does not indicate Ms. Paulson contacted Sutter Homes. Of course she did. She's posted that. So they're saying that she's posted there with that conversation, right, shows that she could not have done it. it doesn't indicate that she didn't. This screenshot of an inquiry made by some unknown persons to Solar Home. Post appears to be some type of draft social media content. The plaintiffs have failed to identify the source or content of the material. It is possible that they obtained this from the defendant's archives, but it's unclear whether it was published. How would they have a draft thing? Right? How would they have
it? To unlock your iPhone first.
Thank you. Why would they have a draft?
You're
welcome. Why would they have something that she didn't publish? Defendants have constantly maintained she did not contact any businesses during doing business with plaintiffs. Even if she had, such conduct would have been protected under the First Amendment unless some additional wrongdoing attached to the communication. Defendants discussed the right of plaintiffs under First Amendment to call for a boycott and to communicate. As a consumer, everybody else but me. Anyway. As a consumer, to companies they choose to not do business with if they choose to partner with plaintiffs. However, plaintiffs have failed to establish that there is no material issue of disputed facts as to whether defendants intentionally procured any breach of contract. Plaintiffs have produced no evidence of any contract. They failed to establish the defendants knew that of the existence of such contract. They presented no evidence that the business relationship was terminated as a result by conduct of the defendants. At best, defendants have presented evidence that Paulson called for a boycott and inquired as to the status of the contracts. And since Paulson denies that she contacted these companies, there is a material issue of disputed facts as to where contact was ever made. They're actually showing, what they're actually proving to me is that it needs to go to trial. There is material issue of disputed facts. Remember, summary judgment only occurs when you have undisputed facts. Plaintiffs are not entitled to summary judgment on their net because of underlying statute. So there's that one. They failed to present evidence. Even if it says it is unfair trade practice to disparage the goods, services, or business of another by false or misleading representation of fact. Theoretically, this permits a party to recover for unfair trade practices in any event the court were to conclude the statement was defamatory. However, this theory of recovery cannot impose liability where defamation does not lie, because in that event, either the statement is a true opinion, non-disparaging, or constitutionally protected. Even if the course of action were available, plaintiff's recovery would be limited to injunctive relief and costs of attorney in the event that a fact finder concluded that a violation was a knowing one. And then it says, based on the foregoing, defendants request that this court deny plaintiff's motion for summary judgment. And then this was dated the 23rd. Well, we'll see how it's done by somebody else. So who is this? This one is, let's go. So this is Amber. This is response to the memorandum of law. This memorandum was submitted in opposition of defendant's motion for summary judgment. Defendant's memorandum in law in support of its motion for summary judgment fails to address the elements of defamation, tortious interference of contract, and intentional interference of prospective undisputed statements of facts. What's undisputed is that it can apply for summary judgment, okay? So just remember, this is written by 7M lawyer. Pursuant to Rule 56 of the Minnesota Rules of Civil Procedure, a party may move for summary judgment, identifying each claim or defense or the part of each claim or defense on which the summary judgment is sought. So yes, there are parts that they can get a judgment on, but there's a lot that they can't. The court shall grant summary judgment if the movement shows that there is no genuine issue as to any material fact and the movement is entitled to judgment as a matter of law. Summary judgment is appropriate when pleadings, depositions, answers to interrogatories, and admissions on file, together with affidavit, if any, show that there is no genuine issue of material. Okay? Material fact, and that either party is entitled to judgment as a matter of law. On the motion for summary judgment, the moving party bears the initial burden of identifying the portions of the record that demonstrate the absence of genuine material fact. A party opposing summary judgment must do more than rest on its mere averments. Instead, it must establish a genuine issue of material fact with substantive evidence. There is no genuine issue of material fact if the evidence presented would not permit reasonable persons to draw different conclusions. Okay? This is my point. Affirming the grant of summary judgment because reasonable persons could not draw different conclusions based on the three pieces of evidence submitted to support plaintiff's claim. All right, so that was the only thing that is undisputed is the fact that they can apply for summary judgment. Here's the argument. Information. Hello, Alberta and Stella. Hello, anyone that's joined. Defendant's motion claims that the plaintiff's defamation claim should be dismissed. It does not specify which defamation claim should be dismissed. Their motion only seems to address count one of the plaintiff's complaint. Therefore, the plaintiff shall respond to the same as plaintiff's other defamation-related claims against defendants do not seem to be addressed by defendant's memorandum of law in support of its motion for summary judgment. Defendant's motion for summary judgment should be denied on count one for defamation, as they failed to address the elements of common law defamation in Minnesota, and their motions failed to identify material facts to support their arguments, which are not in dispute. See plaintiff's memorandum of law in support of motion as to count one. Okay, the elements of common law defamation in Minnesota are that we've read that over, and okay, if the plaintiff's alleging defamation is a public figure, item standard applies for the conduct. A public figure who is someone whose views and actions with respect to public issues and events are often as much concerned to the citizen as the attitudes and behaviours public officials respect to same issues and events. People can become public figures by assuming souls and espousal prominence in the affairs of society, or by thrusting themselves to the forefront of particular public controversy in order to influence the resolution of the issues involved. Public figures must show the defendant had actual malice, meaning the lie was a knowing one, or uttered with reckless regard of the truth. So defendants have failed to address the truth or falsity of statements made by plaintiffs. Plaintiffs have presented overwhelming evidence that the defendant made numerous false and defamatory statements about them across multiple social media platforms, specifics of which are discussed in plaintiff's memorandum of law in support of its own motion for summary judgment. Defendants have wholly failed to provide any evidence showing that there is no genuine dispute of material fact with regard to truth or falsity of the statement made by the defendants, and as such, their motion must be denied as a matter of law. Defendants admit in a memorandum in support of summary judgment that they have widely disseminated statements to third parties. Plaintiff further demonstrated in their own motion for summary judgment that there is no genuine issue of dispute of material fact with respect to the fact that the defendants did in fact disseminate their false statements to third party. So there could be summary judgment. So yes, so it's interesting. Can you see the difference in writing styles, by the way? And this is 7 pages. The false statements were made by the defendants with malice or reckless disregard for the truth asserted. Defendants claim in their memorandum of law in support of summary judgment that there can be no finding of actual malice on the defendant's part, as all of Paulson's reporting, based on reports of others, public documents filed or produced in litigation involving Shin and Hori's businesses. However, defendants failed to provide any case law which supports their contention that defendants' republication of some statements made constitutes a valid defence to the plaintiff's actual malice claim. That there is your bomb drop. They failed to provide any case law which supports the contention that defendants' republication. Don't forget, you can, even if you republish something that is not, it could also be deemed as Defamation. Defendants have failed to provide any proof that they did not act with reckless disregard for the truth or actual knowledge of the falsity of her statements. Defendants have not pointed to a single fact in their argument that shows that she acted with diligence in ensuring that the statements she was making were in fact true. See plaintiff's memorandum of law in support of its motion for the analysis of how defendants' behaviour in fact does constitute actual malice. As defendants have failed to provide any evidence in their motion, let alone evidence that there is no genuine issue of material fact in dispute with respect to whether or not defendants acted with actual malice, their motion must be denied as a matter of law. Defendants have failed to address their element of if their statement were the type that led to harm plaintiffs and lower their estimation in the community. Defendants have failed to address whether or not their statements are of the sort which tend to harm plaintiffs or lower their estimation in the community. Plaintiff's memorandum of law in support of summary judgment outlines how the defendant's statements are of the sort which harm plaintiffs. As defendants have failed to address this topic, their motion fails as a matter of law. Defendants have failed to analyse plaintiff's claim for tortious interference of contract or reference any law to respect the same, but have instead made broad colloquial statements about potential liability of persons not party to this lawsuit for actions not in dispute in the matter at hand. The cause of action for wrongful interference with a contractual relationship requires an existence of a contract, alleged wrongdoer's knowledge of the contract, intentional procurement of its breach, and without justification and damages. Plaintiff's memorandum in support of its motions for summary judgment outlines material facts and how they apply. As defendants have wholly failed to address this plaintiff's claim for wrongful interference with contractual relationship, their motion must fail with respect to the same. Defendants have failed to analyse plaintiff's claim for tortious interference of prospective advantage or reference any law with respect to the same, but instead made broad colloquial statements about the potential liability of persons not party to this lawsuit for actions not in dispute in the matter at hand. A claim of tortious interference with a prospective business advantage requires plaintiff reasonable expectation of economic advantage, defendant's knowledge of that expectation of economic advantage, and defendant's intentional interference with plaintiff's reasonable expectation of economic advantage, and the intentional interference is either independently tortious or in violation of a state or federal statute or regulation. A reasonable probability that plaintiff would have realised his economic advantage or benefit in the absence of the wrongful act of the defendant and damages. As defendants have failed to address the plaintiff's claim for tortious interference, the motion must fail. Defendants claim that the plaintiff's negligence per se must fail as the case purportedly deemed at the statute unconstitutional. However, defendants have failed to explain how this case deemed unusable in the matter at hand. Plaintiff's memorandum of law in support of its motion for summary judgment outlines necessarily facts as well as the undisputed facts which apply to the same. Its defendants have failed to outline deceptive trade practices. They failed to present any law or facts to support their motion for summary judgment on the plaintiff's claim of deceptive trade practices. An individual engages in deceptive trade practices when during the course of business, vocation, or occupation, the person disparages the goods, services, or businesses of another by false, misleading representation of fact. The memorandum of law in support of its motion for summary judgment outlines the standard for its deceptive trade practices claim, as well as how the facts of the case apply. It is improper for defendant to bring a discovery dispute into motion for summary judgment. Now, watch this. There's some gold in here. Defendants have not brought a motion to compel discovery, which they are claiming plaintiffs failed to submit. Defendants have further failed to submit any formal requests to plaintiffs respond to insufficient discovery responses. All correspondence from defendants to plaintiffs on the subject of discovery have contained irrelevant and bullying behaviour without specific reference to any specific discovery requests which have supposedly not been complied with. Should defendants wish to make discovery motions, they should make the proper motions and not try to use their failure to make discovery motions or send professional requests for responses to discovery as part of their motion for summary judgment. Conclusion. Defendants have wholly failed to address the basis of plaintiff's amended complaint and counts listed within. Further, defendants have mentioned no facts which are purportedly disputed in their motion. As defendants have wholly failed to prove their burden required in the motion of summary judgment, their motion fails as a matter of law and must be denied. That, in my opinion, is again a touch. Well, it's pretty. It's very heavily worded. Now that took 7 pages. By the way, that's 7 pages. That whole document. That is how a document is supposed to be said. You've got your point. You explain it, and so she didn't rewrite it. She just said, we explained it in this document. They've explained it. They've mentioned case law. They've then said, this is what, that is essentially how you do it, by the way. All right. So there's that one. Is that the one I've just done? Is that the one? No, then she did another one, did she? I think I did that one. All right, so now we've got the 5th declaration of Jennifer Moore. Well, that's right. I mean, if why didn't they haven't filed? All right. Another. It's going to be interesting. We're not far away from the court day either, so it's pretty cool. Okay, so Jennifer Moore, duly sworn, states she's attorney licensed to practice in Minnesota and one of the attorneys on record for Catherine Mansky-Polson. In her 4th declaration, she advised the courts of steps she took to determine what social media posts were implicated by plaintiffs' amended complaints, since defendants were not provided with copies of hyperlinked copy of the complaint, and the document uploaded to the court's website was not hyperlinked. Because there were approximately 86 reference links, this process was very labor-intensive. After dozens of hours of work, I was unable to locate all the social media complaints. In connection to the plaintiff's motion for summary judgment, a total of 21 exhibits, which appear to be a much narrower subset of documents, provided these posts on December 9, 2024, through a one-box link that did not work. I reached out to plaintiffs for an alternate form of transmission within a day or two, and Ms. David responded, indicated she corrected the link in the upload. I was still not able to obtain the documents. My office reached out to Ms. Stavic again, and the court notified Ms. Stavic that the exhibit should be uploaded to MNDES. I did not receive the documents until very late on December 20, 2024, and I observed that several of the posts were neither linked in the complaint nor were they provided in discovery. I'm uncertain whether some of these posts were actually published to the defendant's Instagram account. A couple of these posts appear to be incomplete draft posts that lack content. Many of the files have dates that do not correspond with any published document. I prepared a table, a factual summary of the defendant's memorandum of present based on my review. Tell me, how on earth would anyone have draft Instagram messages that were unposted by Katie Joy unless she posted them? On May 22, 2023, I served plaintiffs with defendant's 3rd request for production of documents. The last each statement is in paragraph 26 of the amended complaint. Please provide a copy of the Instagram post, reel, or live video, labeling each with sufficient detail such as will be possible to post. Plaintiffs declined to provide these documents, citing work product privilege. Attached to Exhibit 1 as a copy of the respondent's response to defendant's 3rd request. Attached as Exhibit 2 is a recording of an Instagram post made by Melanie Dean and Kelly Wilkin. Exhibit 3 is an uncertified AI-generated transcript of Exhibit 12. Attached as Exhibit 4 is a copy of the lease agreement previously submitted as Exhibit 13 to my fourth declaration, but was rejected for filing. Confidential. I erroneously omitted Mr. Derrick's deposition from my submission, but rather than resubmit, I asked the court refer to my deposition transcript submitted by Ms. Davick in its place. Okay, so here's Exhibit 1. So they're still trying to push the fact that they haven't got the documents. Oh, this is the transcript that's about the AI generated transcript. And I don't suppose, from what I can work out from Jennifer Moore, that she would actually know how to do an AI transcript. But just saying, that's just my own personal opinion. Her hacker center. I'm waiting for the hacker thing. So this is that. It's a keyword summary. And this is, again, her. So it says, when groups are pinned up against that, you'll have members connect. Because remember, she was saying they were only connecting. Then we've got the lease agreement here, which apparently was deemed confidential, which was rejected by the court. Right, but it's here. It's got Miranda Derrick, Nick Rando. Okay, and then so she's resubmitted that. Okay, so that is the uploaded content. That's all the latest there. So what are your thoughts on all of that? Because it seems to be, again, one is very wordy, full of fluff. You can see why there are page limits, because there are just so many. Oh, gee whiz. I've not. See here, this for me, in my opinion, is part of her problem. She posted this on her Instagram. Now, again, they could apply to the court to have this added, because she put on her Instagram, my promise went on. I've got to take this back. Let's just move this forward and then move this back. Oops. Have I gone too far? Here it says, is it? Gee whiz, there's 100 of them. Where's this come from? What? So it says, my promise to Kelly Wilkin is why I keep advocating for survivors. She's made a promise. Is that what we deem and here's another question. She says her son's not involved in her business here, but she's named him. She says, if happy holidays from all of us without a crystal ball. May your days be filled with joy. And so if you're traveling, drive carefully. If you plan to drink, make sure you have a designated driver. If you're alone or no contact with family, please know there are others out there thinking of you. My wish for you all that you have a wonderful time no matter what you do. Thank you for supporting our platforms by watching and subscribing, following our platforms. Without each of you, this job would not be possible. Thank you so much for the opportunity to report on the stories that need to be covered, but so often ignored. Happiest of holidays to you. Katie Joy, Todd V, and our fur babies. She's So for somebody that says don't mention my son, she has now linked him to Without a Crystal Ball in her post. Like, she didn't need to do that. Okay, whatever that is. So, then that's congratulations to you. Someone is engaged for breaking the cycle of, I don't know who that is. Shari Frankie, I don't know, someone's engaged. I don't know. May this chapter be filled with happiness and the privacy that you most certainly deserved, but she's just post-blasted it everywhere. Happy birthday to my sweet friend Kelly Wilkins. She's one of the most amazing women and mothers I've had the chance to know. Over on TikTok, I've been interviewing family members of Dee Dee Blanchard, so their voices are heard loud and clear, apparently. Another thing she shouldn't have. So let's look at Miss. I'm going to go to Miss Ball's page because that's where I saw the fallout from Camille, and I think Abigail some too. So Camille. I love how Miss Balls does this. Welcome to the dark side, Camille. You're most welcome. Don't come in my DMs and act like this, shared Katie. And then just had the most lovely conversation with Glamour Queen. If you see her around, comments show her you're welcoming. She's giving me permission for me to post. Come to find out, Camille was not allowed to be mod for KJ, but Ray and Faith are. Camille told me it's obvious KJ hates Ray, but only allows her on panel and to mod because she kisses KJ's clam so unbelievably hard. Ray also hates me, and think I have no life. If only she knew. KJ literally told Camille she was a journalist and instructed her to block all the anti-KJs, so Camille wouldn't find out who she really is. Camille also didn't know that KJ accused me, that's Miss Balls, of wanting to unalive her goblin in the worst way possible. I let her know that it's no big deal. KJ and Ray have called me mentally unstable because they do that to everyone in an attempt to discredit, but anyone with a functioning brain knows that's a load of malarkey. Carmel did say that Faith was really kind to her about this situation, and I can't fault her for that, but supporting Katie and her horrid behaviour I do take issue with. Anyway, thanks, Faith, for... Anyway, another one bites the dust. Is the... So, and I think... And she's been on live for... And now I also heard that she started memberships on TikTok, so she obviously needs some money. She had 9 clips on TikTok today. Non-stop since yesterday. Didn't she stop and smell the roses over New Year and Christmas? So this is from Camille with a message that Ray KJ's mod sent to Camille. So, there's a fight me Luca moment. Hang on. Well, hopefully she will go live on YouTube. So let's, oh, gee, look at that. That's a big write-up. So let's have a look. So this was, we'll watch some of this. Let's have a look at this and have a listen to some of this. Apparently she was on live for 4 hours. And she says in this one that she won't be on for long because she hasn't showered yet. All right.
Hi, friends. Okay, I don't have a ton of time because I need to get in the shower and actually get dressed for the day. Hello. So there was a bunch of stuff that, well, a video that was placed on Gypsy's story, okay? And this kind of should tell you and confirm to you what I've kind of been saying to you all along about her relationship with Ken. Because there's been so much focus by content creators about if they've broken up, if they are still together, and what's the status of their relationship. And I have said from day one that this relationship is on thin ice, has been on thin ice for a long time. And that quite honestly, no one should really be focusing on the status of the relationship because this is not a relationship that anyone would want to be in. Okay.
The thing is about going live on YouTube is that everybody can watch and not be subscribed, you see, and she knows that.
So if you guys could get started in this live by tapping, and help me by sending out, starting with throwing some gifts of some kind. We'll change our goal today to something. Yesterday we did corgis. We'll change today to, let me find something. Let's find something that you guys can all participate in. That's not a lot. Let's do donuts, since those aren't a lot and a lot of you guys can participate. We can get those gifts thrown.
So she needs money.
All right. So Faith, you're in here.
Essentially, she's saying she needs the money.
Okay.
Hello.
Hi. Okay. So what we're talking about is that Gypsy has sent a bunch of videos to Ken. I already said last night that the other page, the Rusty Wrist page. Now, please keep tapping, you guys. If you need to tap in my box, you can tap in my box to help me get up to. Don't quit tapping so we can get onto the For You and get people to see the video. No, this is not the scammer on the screen. That's just a video. That video is actually of a guy that made a video basically saying that pay attention that guys that are balding early are actually cheaters. Oh my goodness. Thank you, Vanity. Thank you so much. You guys are being amazing. And the video is, here, I'll pull it up. She sent him a couple interesting messages, but do you guys remember that back in July, I had said that Gypsy and Ken had gotten into a fight because she was jealous of Ken having photographs of his ex phone and his phone.
Yes, I remember that. I remember. And she was going to, and that's the same girl that she wanted to like dox or something, at least.
Yes. Yeah. And I told you, like, there's a lot of jealousy in the relationship. There's a lot of back and forth that goes back and forth. Like, they had to have a sit down with Christy where they basically were like, is this how you're going to have your relationship where you're being petty and you're accusing each other of cheating all the time? Because the distrust went both ways, because when she would fight with Ken, she would run to Ryan. So what she said to, what the hacker released this like video basically of the messages that she sends to Ken. I also told you in a story last night that Gypsy doesn't talk to people via DM. Like, if she's going to talk to someone like Ken, call him on the phone, or she's going to send him a text. Like, it'd be no different than me talking to my husband. Why would I send my husband a DM on social media? That doesn't even make sense. If you have somebody's phone number, you know that they're going to see their text.
Because I mean, how do they communicate in her home?
Messages before they're ever going to check an app. The messages of her saying that she killed her mom are fake. They're not real. The hacker actually said that that page is not associated with him. Those are not in his messages. And he showed all of the video. He showed all of the messages between Ryan and Gypsy, and those messages are not in there. Yes, people send videos via app, and that's what she did. She would basically forward a video to Ken. But she's definitely not. And why would people think it's weird? I just want to ask something. Do you guys realize that Gypsy went to prison for killing her mom? You realize that, right? So why would you think it would be like this bombshell of her saying she killed her mom? Isn't that what her charge is? She already went to prison for that. That's what her sentence is. She went to prison for killing her mom.
You can hear her son in the
I mean, her and Ken can call on the phone. Ryan can text. She's texted Ryan. She's shown that she has the ability to text him whenever she wants. So why would she have to have all these little and stuff? Her conversations that are important are not going to be in a TikTok DM.
No, not at all. Also, I said yesterday, and I'll say it again, those videos that post, or that TikTok account that's supposed to be Rusty the hacker isn't him. He literally, I have messages from people. He's apparently told people on Telegram that it's not him. Like, those aren't the messages. He posted a video of what is on in between the messages between her and Ken.
I mean, from what I understand, there's not even a lot of DMs to actually show.
No.
Like, there's barely anything on her TikTok as far as like privacy stuff.
Yep. Faith got exposed on my other phone, so I don't give a fuck. What is that?
I have no idea what the hell that is. I don't even know them. How exposed? Tell me. I want to know what got exposed.
Yeah, like
What do I get exposed of? Is it a picture of me naked? Could you post it? Is that what it is? 'Cause I don't have those. Like, what did I get exposed of? Faith got exposed on another phone. I don't give a fuck. Who are you?
right. I'm gonna just remove them. Okay. So oh, these people are totally in here to try to trigger you, Faith.
It's a.
No, no. Second degree murder or schmurder is actually killing someone. Okay. I don't know where people think that a second degree schmurder isn't killing one.
The difference between usually the difference between first and second degree is intent. By the way, it's all to do with intent, because or and manslaughter. So in Australia, we don't have we have murder and we have manslaughter. So and manslaughter is sort of like accidental, and so if you did not intend to kill somebody, that's manslaughter. So it comes down to intent.
Because that's what it is. Okay, so she's a convicted murderer. Now, Gypsy has publicly lied and said that she's been charged as an accessory after the fact, and that's absolutely not what she was charged with. She's a legal murderer. That's on her record. She did the act, and it doesn't matter. It doesn't in all states, let's be clear. Whether you're holding the weapon or not, if you orchestrate it, you steal the weapon, you send the person, you hire a basic hitman to do the job for you, you killed your mom. Why we are even discussing this when we know that those are fake? No, she's not admitting to doing the stabbing. That's not what those fake text messages say. Not at all. Okay. Jen is not allowed on. Jen, you can never come up here. I need to someone block her. No, I want to send you an invite. No, don't come up, Jen. You're not invited. How do I block you? Jen, you created so much drama on the platform. I don't want you in here.
See, she goes to block people and then tries to invite you up. I've had that happen to me, and then makes this big song and dance that you're trying to like get onto her. Yeah, so the main difference between first and second degree is whether it was planned or premeditated. So first degree is the deliberate or intentional. Second degree is not premeditated. So again, as I said, we don't use in Australia first degree or second degree. We use we only have first degree and manslaughter, just so you know. All right. So when they say Gypsy pleaded guilty for second degree, and also it's a lesser sentence, so you're more likely you'll get a lesser sentence for second degree or manslaughter than you will for first degree or murder, just so that you know.
Block. Mute. Okay. Yeah, anyway, so she was given a reduced sentence as a mitigate the amount of time she got in prison, not because that's what it actually meant. The prosecutor's own press release said that he had the evidence to turn on first degree. Okay. Today has been kind of a mess off TikTok. We've been dealing with some drama, and so it's just unnecessary to like.
I don't even know what I did. I don't know how I got exposed because I don't even talk to nobody. But like, I mean, literally, besides my family and my husband, the only person I talk to outside of that's like Katie. And because like I really don't even have a life. Truthfully, besides my kids, I have 4 children, so I don't really know what I got exposed for. But I would love to know myself.
Yeah. So you didn't get exposed, but yeah, the live title is it true? Just came in. Okay, so I told you in last summer that they were fighting about cheating. They're fighting about cheating.
Isn't it funny though that she always has a drama? There's always drama wherever she goes. Always drama.
There's a lot of insecurity in the relationship because Gypsy's a cheater. Gypsy's never been loyal to anyone.
Allegedly.
She was never facing the death penalty. That was never stated. In Missouri, it can be charged that way, but they didn't make a determination. So it was never a further thing. So that's not true.
That's her.
Okay, so she sent these. I'm just going to show. I can change the box here to see if I can do this. Give me a second. Okay, let me clean my, hold on. So the hacker shared the screen record, right, from Ken's phone, okay? He goes to Ken, goes into the messages. That's him talking to Ken yesterday about buying the account. She sent him a video of this Maddie, who basically she was postpartum and her husband was like worshiping the ground she walked on and massaging her feet, taking really good care of her. And she said, I hope you're as caring as her man is, okay? But then she sent this video. It says, when you aren't in the Christmas spirit this year, my attitude, LL. And it's a video of a woman throwing the tinsel and the ornament on the tree, annoyed. Ryan didn't say he was the father because those were fake messages. I'll show you the whole messages from Ryan.
I've only missed a whole lot. I don't like, and my care factor is 0, to be perfectly honest. But obviously, there's a whole group of people that's invested in Gypsy Rose, and so that's where she's making her money at the moment. But as I said, I have not touched my computer since before Christmas. I've not been near my computer. I've actually been living life. So I hosted Christmas. I've packed up Christmas. It's my mum's birthday tomorrow. I'll be spending time with my mum. Then it's New Year's. Plus, I've been watching the cricket. Tomorrow's day 5 of the cricket. Looking forward to that. So I've been living life, people, and having a ball.
This video is a video mechanic. It's a fake scene, and it's basically of her, Rose raising a child by herself and Jack not being in the picture. And she sent that to him on the 18th. Okay. After she sent that, she sent him a video of a guy that says, men who cheat and lie go bald early. You'll notice that? And she said, oh, LOL. And the next one was, we were just starting the Christmas spirit, my attitude. So they fight a lot, you guys. And so she's always accusing him of cheating. He's always accusing her of cheating. If you notice, he didn't respond to any of that. I don't know what this video is, something about.
But why is everyone surprised? I mean, the whole circumstances between Ken and Gypsy getting together were iffy anyway. Who was ever going to think that was going to your grandbaby's joining day? Cool. So you'll disappear at some point in time to be a grandmother, right? Well, my daughter told me she's not having kids, so I was a bit upset about that. Because you get to an age where your kids are adults and you go, I've got to start looking forward to the next stage. And then she says, oh no, not kids.
Christmas special boyfriend, I don't know. I couldn't find that video. Me trying to shave my hoo-ha. He responded to those. Trying to absolutely do anything while pregnant, some kind of bacon wrap thing she wanted, some sort of a show. And then memories. Christy tells Gypsy why Ken broke up with her, and she says, memories, LOL. And then she sent him videos of Bree talking about Gypsy and the pedo thing and couples poses. So those are all the messages to Ken. Does everyone see that?
Yeah.
These are all the messages to Ryan. He goes to Ryan, okay? Tried to engage with Ryan.
I don't really understand what. I mean, I must admit, I've zoned out because I've got.
Okay. Another hi, and that's everything with Ryan. There's no I'm the father. There's no Ryan. I just want to be with you. This was shared from Lucy's page. See, in her stories. So I want to prove to you that all these other messages are fake. That's all that's fair.
Can we say how Ryan looks like a sad puppy? Like, what the hell?
And she asked for a face-to-face on December 4th, right before their court case. And this is what the hacker showed. This is in the stories. You can go to Gypsy's stories right now and see this. It's from her 9.8 million account, her stories. All the other pages sharing the other screenshots are fake. That's all that's there. Then they're in. Okay, that's it. Oh, but look when he puts in K. Look, what's that? What was Gypsy searching for K? Me. TikTok will put up what you've automatically searched before. And when he put a K up there, my name came up, meaning she.
But that's not her picture.
For me. So there's that. Yes. So a lot of people will say she doesn't. She's tried to say she didn't know me. We barely knew each other. All of that. I was connected to her stepmom for 5 years. So those are all the messages that are from his DMs. Okay. And oh, where did Faith go? Faith go?
Hello.
Well, I'm not a gypsy creature. Oh, her baby's crying. Okay. Got it. Sorry, I was trying to show you what was in here. Okay.
I'm not a gypsy.
So,
warrior.
So this is when she sent him videos. I didn't buy her account and I'm not in her account. These videos are shared on the stories of Gypsy's page. The hacker shared this on her page. Stop trying to gaslight me and claim that look at this. What does it say? What does it say? Gypsy Rose TikTok.
Can't see that.
Does that say a story? Oh, it's a story.
What on earth is she doing?
The whole video that was shared in her story is this. I'll show you.
What on earth is she talking about? Oh. Don't question her. Oh dear.
That was all that he shared on. This is my screen recording her story.
Her screen recording.
Okay. I'm not looking at too close. You should be able to see. Look, Gypsy Rose TikTok. My screen recorded.
Gypsy.
All you have to do, you guys.
I said the same thing. I can't see what, but it's cutting off a little. We can't see the full screen. Don't you dare question it.
All you have to do is go to her stories. You can go look at her page. Doesn't matter if it's off center. It doesn't matter if it's off center. All you have to do is go to her page. The story is on her page. We did know, Alanis. You guys are trolling. Like, it's ridiculous. Why are you trolling?
Then don't.
I really moved today. Very much so. Wow, guys.
I'm not gaslighting people. How am I gaslighting people? By showing you on my screen what I showed you. That's not gaslighting. And the full picture, if you need to see the full thing, is on TikTok on her stories. Click her profile pic on her stories. You will see that there's an active story that shows what I just showed you.
Oh boy, that's funny.
Now, you're not going to see it on the desktop version, so you would have to go to her, you have to go through your phone. All I'm showing you is what is on the hacked account story. See?
You can't see it.
That's my screen record of what's on the story of the hacked account that I took 24 minutes after they posted it. It's in the video. The video right here, which is the story, shows what she searched. Look, you put an A. Here's my name. I'm not following the hacker. This is Gypsy's account. See? Look, Ryan, Joy. That's the video from his story. This is what's in the story right now.
Right,
And I was always clear about what I was showing you. So if you didn't hear that, I'm apologizing.
so they know she is hacked. Well, that's right. And don't forget, it's only hacked if it doesn't match her narrative. Remember that. It's only hacked if it doesn't meet her. If it doesn't match her narrative, then she's hacked. Oh boy, that's funny. She was not happy about that, was she?
Okay, goodbye, user.
I thought about setting another.
So this is what's in her story. And if you take a screen recording of it, you slow it down to see what's in the messages, which isn't very much. Okay. I took this screen recording at 11:09 this morning. He shared it this morning. The whole thing is like 40 seconds long. I'm not following this. I just went to this on my private account that I have, like my not public, personal, whatever, TikTok.
Oh, she's got 2.
So what I did then is I looked at, oh, what are the videos she shared with him? Then I looked up those videos.
On her private?
Her account that was hacked, but anyone else you said was following that and that whatnot was illegal. I never said following this account is illegal.
So she's admitted to having another account. I wonder whether the court knows about that. Oh, hey. All right. So that was clip 1. Gee whiz. 2. All right. Now I think she's going to go after Camille in this. So,
Okay, here.
The chat's a little funny today.
Yeah, I feel like they're coming because of what Camille did.
Oh yeah. I think that's what was being said, that Faith was exposed, because I don't know if he sent to Faith, but she was blowing up her phone, and Faith said I'm not going to open them because this is just too much.
So earlier today, a couple of my moderators were getting messaged relentlessly. A girl had been on our panel. Her name is Camille, and she was never a moderator here. She appeared on my panel like over the summer a couple times, and she was someone that was trying very hard to, I don't know, maybe befriend me in a way. And that can happen, but I keep my distance. Yeah, and she went into Ivory's thing last night. And so she was on my panel right after the book came out. And we were talking about the audiobook and how the audiobook works, okay? And she kept talking about how Gypsy sounded terrible on the audiobook. She didn't have emotion. She wasn't talking about things with emotion. And on the panel, we were trying to explain to her that when they record audiobooks, they have to do it a certain way, to articulate the words a certain way. We'll start and stop the sentences and repeat and re-record. They have apples in the session to help people be able to enunciate and pronounce words, and that having a lot of inflection in your voice isn't uncommon in an audio recording. And we kept just trying to tell her that, like, that's not how it works. And we were trying to say to her was like, yes, we understand that it appears like she doesn't have emotions, but that's not a good like argument to use because of the way the audiobooks are recorded. It's a job. You have to like be clear and concise. And she just wouldn't drop it no matter how many times. We tried to explain it to
of course, Katie's the expert on audiobooks, right?
her, and she just kept talking about it over and over and over. And I had people in the chat trying to explain to her how the audiobooks work, and she just kept going and going and going. And I couldn't get her to move on. So eventually I just had to drop her from the chat. And I told her after I dropped her that it wasn't personal, but I wanted to stay on topic and not have it sort of derailed by that. Yeah, she was saying that she wouldn't be able to read her own book. If you have this much trauma, how can you read a book like this?
Yeah, you had sent me several messages about you and how I'm just a sheep to you. And I'm just like, can you not? I've therapy how many years?
I wanted to follow all my fan accounts. I wanted to spam thing. I wanted to just see what they had to say about me. That's all. I'm back though. All right, guys.
We're just talking about what happened with.
Oh yeah, that was something.
So after she dropped, I got like a 2-page message from her where she was basically telling me that I was crazy and that I needed help. And she couldn't believe I would be so disrespectful. And not everyone is like this or that. And I respond to those messages because I felt like when you send me 13 messages and I haven't responded, and it just keeps getting more and more aggressive, I feel like responding is going to be productive. So I didn't have her back up on panel. She was never a moderator. I didn't really feel like there was really that much to say about it. So that's kind of how it ended. And then last night when we were watching Ivory's live, a bunch of us saw Ivory trying to negotiate to buy the account from the hacker. We have video of it. And Camille got pissed off and said we were slandering Ivory because she didn't try to buy this. And that I'm defaming her and I'm defaming Ivory and how dare I defame Ivory. And it's like, but we all saw what we saw. Someone in fact posted the 11-minute conversation between her, Ivory, the translator, some guy named Check something, and she said she would go in on half of $500 to buy the account. It doesn't matter if she said that, she repeatedly, and that's the thing. She was talking about buying it. It doesn't matter if after she decided not to buy it, that she walked it back and said, I was just doing that because. And all I did was say, there are creators on here that are offering to buy this. a really bad idea. Why would you negotiate with a hacker? I listened to the live and I don't need to be told what I heard.
But, oh no. So people are saying, no, she never said that. But of course, yeah.
Okay, the point is that you honestly cannot sit there and negotiate a price with somebody on live for illegal activity. Period, point blank. You know why? Because the police or anybody looked at that, they can't say, oh, I was just playing. I wasn't actually going to buy it. That's not how life works, okay?
She was not alive negotiating to buy it. Period.
And even asking the guy's PayPal and then having someone offering to go halves. If it was just a joke, why would she not just say, I'll pay 500? No, she wouldn't even be out of the 500 then, right? Why would you have someone go halvesies with you?
And Nina suggested that she use PayPal because then if they don't get it, she can just dispute it. It doesn't matter if no money went. The point of my live wasn't that she bought it. They were negotiating to buy it.
Thank you. The fact that his offer was there, that's still legal, and no money went through. And money didn't go through because they realized really quick when he dropped out of the box and disappeared before they could get a call or information else from him to be able to buy it, he disappeared. That's the problem. That wasn't because, oh, she just said, I was just kidding. Never mind. No, the guy ended the conversation, not the other way around.
And what apparently is offending people is that the fact that we saw her ask, regardless if she did or not, and negotiating with him, regardless if she did or not, it's wrong. And that was the whole point of what we were talking about over here. So you're telling me that if you met with a guy that sold an illegal gun and you asked him how much to buy the illegal gun, and then you didn't buy it, it wasn't wrong to ask the guy how much to buy the illegal gun?
What if she was working with law enforcement? I'm just saying, sometimes don't they do undercover people to do types of stuff like that? I don't know. Someone says she's not that stupid. If that makes her all feel better to think that, then go ahead.
The whole point is the only thing Katie said was that creators would not be trying to offer or negotiating with a hacker or somebody doing something illegal, period. There is a moral compass that says if someone did something illegal, you do not negotiate with them. So you don't negotiate with terrorism. You don't negotiate with hackers. They're cyber terrorists. That's the whole point. It is morally wrong. And then Camille took it and ran with it, and it was just an explosion of stuff. That's it. People have different opinions of negotiating with someone who is doing something illegal.
The girl's still going off. Like, I had to block her. I blocked her on my Instagram and I blocked her on here because she was just going at it.
And then, so because what we said was what we knew happening was wrong. We don't care if she bought it or not. We don't care if it was there or not. We don't know if intentions were there or not. She didn't share her intentions until she started getting kickback in the chat of people telling her that what she was doing was wrong.
And then she didn't actually come out and say she wasn't going to buy it. After the guy already dropped off her pay and disappeared. And Nina even went and checked to see if the guy was coming back or if he got blocked or banned. They literally made sure there was no way they could buy it before it was ever said they could not. They were not planning on. That is the difference. You can make content without having illegal people or people doing stuff wrong on your panel.
So she wasn't standing up for Ivory. She was
I would like to know whether Katie has offered money to her hackers to get her Facebook back, actually. That's what I would be interested in knowing. Okay. I'm going to call it quits after this little bit. More. Well, that's right. I'd like to see what she says. I'd love to read the private messages.
basically mad at me and using her, Ivory, as like I don't know how to explain this, but she felt wounded by me. And so she thinks that if she goes to Ivory and becomes Ivory's biggest defender and tries to start drama between Ivory and I, that she can somehow weaponize the anger she has towards me and inflict it into Ivory's chat. And it's not okay to hack someone. It's not okay to have her to buy a hacked account. And that was really the only point of our entire conversation.
That's it. Like, it's not nothing like personally attacking Ivory. It's not nothing saying anything. It's just like more like just for us over here, we just would not have had that. We just would not have cooperated with that. That's it. That's all.
And then she got mad and over to Ivory's panel, said all the nasty stuff. Yeah, it's not okay to pretend to do it either. Exactly. Because you don't say someone didn't stay for the whole entire live. Say someone that was like 15 just watched for 10 minutes. This was an age restricted live. They're going to see a woman in her 40s offering to pay for a hacked account. who all of these people are that want to join.
Dude, ever since I've like defended myself against Sheena and stuff, like I just have to. It's not trying to fucking beat on me. Like I just keep getting pushback for that for some reason.
The hacker actually shared his PayPal account when he posted the story. He's not trying to hide his PayPal account.
I'm not worried about getting in trouble because he's from another country. There's nothing the United States can do to him. They're not going to extradite him over TikTok.
Right. Exactly. So I don't have anything personally against any of these people. One, we last night we didn't want anyone to get scammed. We don't want anyone to pay any money. Okay, no, Sasha, you were defending ethical hacking last night.
Actually, I was talking about it. I was talking about there's ethical hacking. There is actually ethical hacking. Governments do it sometimes, and defense forces do it sometimes. It's ethical hacking. Is there a need for it? Yeah, she says, I don't know her, but she searched for me. I know she got excited because Gypsy searched for her.
It doesn't matter what the amount of money he wants is because I'm not paying him, and I'm not going to talk about paying him. Like, you don't pay for a hacked account.
I guess
And that's,
By the way, anybody who offers to buy an account, regardless of your intentions or not, it is illegal on TikTok to sell accounts. It is illegal. It goes against TikTok's guideline to sell to each other, even your own account. Katie couldn't sell her account right now. Like, and she's the one doing it to anybody. You're not allowed. So her offering to do that on live could have got her deplatformed.
yeah, it's a violation of terms of service. And YouTube channels can be sold. Where to draw the line? So the point is that entire scenario brought up and made Camille angry so much so she came to my chat and said I was lying and defaming and being bad and blah, blah, blah. When I said, I don't want to deal with you, Camille, you called me crazy. Then she got even more irritated and ran to Ivory and basically was running her mouth to Ivory and saying that we're slandering her over here. Then this morning she was on Jen's panel. She's just trying to hop on every panel she can for whatever reason because she's mad about what we said about Ivory.
And it wasn't even anything negative. It was literally just, it's not okay to buy someone's hacked account or pretend to. And also it can get you deplatformed because it goes against the terms of service of TikTok. Like, it is bad to do that. And every creator that was on her panel last night, even like Nina, Morbid popped up, a lot of them popped up and we're entertaining it. Check the star, all of them. We're entertaining this hacker. Could get them deplatformed for entertaining it.
So all I'm saying is that she was someone that tried to be in this group. She wanted to moderate my page. She wanted to be on my panel all the time. She was someone that came up on the panel a few times, and now she's upset because about getting removed from the panel because we were talking about a book and she wouldn't let go of a certain topic and we just want to move on. And yeah, so.
How dare she not want to move on from a topic? Thank you, but that's good so people can come in and out. Well, that's good. Thank you. Coverage on the docs. Yeah. So I said, it's very interesting how Amber can do in 7 pages what the other one does in 20 or whatever.
Morbid actually told her to use a third party if she wanted to buy. I have a whole clip. There's a whole clip being shared on YouTube, on Facebook. Someone's recorded the interaction with the translators. And the Blanchards are very litigious and they will try to get people arrested. And so I was saying to people, like, don't walk into situations where illegal activity is happening and wave your flag on a live, potentially making you a target. The Blanchards who will use this, weaponize this against you. They will. They've already tried to get Fancy. They tried to get Fancy arrested so many times. They have tried to get Ivory Rose Wild arrested.
Not even that, but anybody who was on that panel, regardless of what they had to say, like, truthfully, could have got, like, all the Blanchards are going to do is have, you don't think they don't have screen recordings, everybody that was up there doing that? You don't think that they don't have their own people, like, in there getting recordings as well? All they have to do is send that to TikTok, and everybody who was on that panel, not only could they get them for illegal activity, they could get them deplatformed. You would lose everything. I mean, it's just not a good thing. Like, you think Gypsy right now is not trying to get her account back? You don't think they're not scrambling and she's got all these people trying to help her do so? She's not just sitting there like, oh no, it's fine. You can have my TikTok.
They're very spiteful and they will do this to people. Like, these people do not have an ethical bone.
Okay, so when she says these people do not have an ethical bone in their body, is that considered defamation? I think there was a limit of I know that they were over limit. There was a limit. Minnesota Civil Court page limits. There was a page limit. That's the Appellate's Court. No memorandum of law submitted in connection to either shall be exceed 35 pages. So she was okay on the second one. If a reply shall not exceed except with permission from the court. So that's what it says. So yeah, it's a oops, it's lost. Apparently, we've lost connection to audio. Whoops. You missed the whole. You may have missed the whole lot. Well, no, you probably haven't missed much. She's just talking about.
Use my moderators to do dirty work. I don't want them to troll people. I don't have them troll people.
I mean, if you didn't know that Scarlett was trans, and I don't think it should be an issue, but Katie just tells everybody here that she's trans. I mean, is that something that she should be doing?
That's not like how I ever run my business. And Jesse Bear can tell you in the chat more than anyone, Jesse has been with me since 2018. I'm very hands-off. I don't have groups for my moderators. I don't have Discords for my moderators. So can Scarlett. You've heard Scarlett on this panel talk about our relationship. I mean, my relationship with it is incredibly unique. Same with Jesse, because we were there during Scarlett's transition. So we have like a huge connection and bond with it because she trusted us when she transitioned. And so we've been with her through all of that. So it's just our life.
I mean, really, we honestly just get like the live shared to us that she's live. It's not like, oh, we know when we're going or who can be there. But none of that. It's not like a planned thing. None of these lives are like meticulously planned out. And we don't have conversations about what's going to be said or none of that at all.
I just try to stick to the information that I have. I try not to like inflate the information, and I just try to do what I do. So
She tries not to inflate the information. Oh dear.
Sometimes if I share an opinion about what another creator is doing, maybe that creator won't like that opinion. Maybe they don't like that I don't appreciate the way that they do their reporting. That's fine.
And that's when everyone's in the chat like asking about like certain topics, we don't really like get into those topics because most of them are surrounded by just drama or rumors or something like care about pregnancy. We don't really care about who she's actually with, who the baby's father. None of that actually matters to the point of the whole story. That's just drama. And we don't get into stuff like that. That is nothing to us. I mean,
The reason why I shared with you what was shared on her story today was that I have told you for a long time that focusing on Gypsy or Ken's problem doesn't help any of this, because it's actually Gypsy that's instigating the unhealthy dynamic in that relationship, because she's a sociopath and she enjoys hurting Ken. I've said that from day one. Everyone can get mad at Ken and get mad at Ryan, but she's the one that enjoys triangulating them and causing damage and pain. And then she has these men gaslit. They feel like she's the prize that they're going to win. And they are all competing to win Gypsy Rose. And she makes them believe that she's the prize that they should want.
Oh, it's funny how I had that problem, hey?
Lane shows up here all the time. I tried not to block her, but she'll be blocked now. So, and for, I've said for a long time about Ryan's lives, people are like, oh, he's so pathetic. Why won't he move on? And I've tried to tell you guys, like, it's not that he won't move on. It's that Gypsy won't let him move on. Gypsy is, I'm not a psychologist, but, or a psychiatrist, but people that have evaluated her, that are psychologists, or people that have about the case that are psychologists or psychiatrists, like Dr. John from Hidden True Crime, he did an analysis of her behavior for different interviews and how she acted. He said that she shows symptoms or signs of having antisocial personality disorder. And a lot of what that's about is attention-seeking behavior, triangulating people, not caring about social norms, not caring about hurting people, thriving on drama, thriving on chaos, instigating chaos in people's lives, like getting people to fight around her. She loves it when creators fight, which is why we try not to get involved in the creator drama.
That was funny. Try not to get into creative drama. All right. Yeah, so that's clip 3. I don't know. Anyway, I think I might leave it there. So we've got to do clip 3. No doubt she'll be back up. She'll be on live again at some point in time. But anyway, so yeah, I came on because I wanted to talk about the court documents that have been filed. I'll keep in. But remember, don't forget, we've got the court date in January. February. March. I just read the John Farnham biography, and there was some really shocking things in there. One of the he talks, and he does talk about being starstruck by certain artists as well. But anyway, so don't forget we've called. Oh, it's getting close. It's getting close. Look. The 6th of the 1st. So get ready, because I reckon there could be some spiraling. We did that one. Yeah. Yep. So there you go. We did it. We be prepared for some spiraling, because I reckon she's going to spiral, in my opinion. So don't forget, everything, particularly about the legal stuff, is just my opinion. As I said, I think, in my opinion, there are too many facts. Too many facts that need to be cleared up. So, because once you have those certain things cleared up, you can then work out how the case is going to proceed. So, in my opinion, they need to sort out, they need a ruling from the court as to whether she's a journalist. If she's a journalist, then she's got more protections. If she's not a journalist, qualified privilege may not be able to use. Oh yes, thank you, lawyer. Thank you very much for that. Are the Derricks and Robert Shin public figures? If they are, is there proof of malice, actual malice? Now, if it's deemed that Miranda and James are public figures, but Robert isn't, he's treated differently. And so while they may not get that for James and Miranda, they may be able to get the malice for Robert Shin. So can you see how all of these, depending on, and is without a crystal ball, a media outlet. If it's a media outlet. But if she's not a media outlet, if she's republished information from other people that could be deemed defamatory, then is that defamatory because she's shared something from other people? So there's all these. It is my opinion that all of these things have to be determined before there can be a ruling, because once determined, it then narrows down and answers a lot of those pending questions. Because if she's not a journalist and she's just a social media gossiper, right, then there's a bigger, it could be said that's more than likely she defamed him. But and media outlets, particularly in Australia, they've come down very hard on media outlets recently, and a lot of media outlets have been in trouble. So that is not just because you're a media outlet and you have qualified privilege hasn't really meant much. So and don't forget, you say that could give a perception about somebody else. So is the way that you edit it give a perception of something that could be defamatory? Defamation is very interesting. But again, I'm just talking about my opinion. But look, you are welcome to do your own research and speak around. Everyone has a brain, and I'm happy for you to use it any way you see fit. So anyway, she needs public figure. I think that's the strongest point. So waiting to hear the Britney. Yeah, well, that's going to be an interesting one. Everyone's going to wait for that one, I think. Because I talked about last week the politician that got fined. He was the leader of the party. Well, what happened was there was a decision about the person that sued him was out of the party, and he had the deciding vote and kept her out. Well, in the meantime, what's happened is that after Christmas, so we had Christmas Day, which is a public holiday here. Everything shuts. When the few days that all the supermarkets are shut, when the few days. Boxing Days, it was a public holiday. The following day, so that's Wednesday, Thursday, Friday, the guy got ousted. He got rolled as leader, and she got put back in. So it's been bizarre how all of this has worked. I haven't heard anything about that decision, but I would assume that once it's done, it's going to be all over the media. And they take a very long time. Because they need to make sure that if there is an appeal, there was the Brisbane case is still going on, and I remember the judge over costs between Channel 10 and Lisa Wilkinson, and he sort of said before Christmas, he says, I really wanted to put this to bed before Christmas. I really wanted to not have to worry about this again. Anyway, it's still going. They're still fighting over costs. So anyway, I want to thank you for joining me. I hope you have a good new year. If I don't get on, make sure you have a good new year, and I'll either see you next year, or I might even spend my New Year's Eve with you, and we'll have some. Might be good to see the new year. You could have 2 parties, one with me and your own. But yeah, it just means once January hits, when we get to the end of the month, it means I'm back at school. So I've got to enjoy these last few weeks. I've got a little bit, and she would look lovely sprawled across the Bentley. I wonder whether if Katie loses, she has to give them a beamer. So I'm home, so I can join you. Cool. As I said, I'm not. I don't have any plans at this stage. I don't know. You never know. I could get lucky. Who knows? Stranger things have happened. You know, who knows? But yeah, we'll see. Anyway, thank you. If you could hit like and subscribe and say hello underneath it, that would be great. And I hope you all had a good Christmas. And I hope that you have a great New Year. See you beforehand. Anyway, until next time, please keep safe and hit like and subscribe. And I'll catch you next time for now.